Good afternoon. I'm Jonathan Enton. I'm Associate Dean for Academic Affairs and a member of the faculty here at the law school. It's my pleasure to welcome you this afternoon. Thank you for coming or for joining us over the webcast. We're delighted to have you here. I have the honor of introducing our distinguished speaker today, but first let me thank Professors Calvin Sharp and Kathy Hessler for hosting this event. Professor Sharp is the director of CISCDR, the Center for the Interdisciplinary Study of Conflict and Dispute Resolution. He's also the John D. Verdrinko Baker and Hostetler Professor here at the law school. He teaches and writes in the fields of labor and employment law, evidence, and alternative dispute resolution, and he has been my colleague for my 24 years on the faculty, and I won't embarrass Calvin further than that, other than to say he was here when I arrived. Professor Hessler is our center's associate director. She's on the faculty of the Kramer Law Clinic. She teaches in the civil and mediation clinic. She also does a seminar in animal law and teaches in the Case Arc Lawyering Skills Program. CISCDR is the product of their hard work and vision. It aims to encourage greater alternative dispute resolution sensitivity and skill development in our students. One of the core initiatives established by Professors Sharp and Hessler through the center is a lecture series to further the center's mission of preparing students for the multiple roles that they will perform as lawyers. Each lecture in the series has a particular focus, one in practice, one in theory, and one that is truly interdisciplinary. Maya Angelou was the inaugural speaker for the interdisciplinary lecture last year, and someone as exquisite and brilliant is being recruited to follow her memorable visit. The CISCDR Distinguished Visitor Lecture is an annual forum that brings practitioners to share their insights from their experience. Dennis Ross, who was the chief Middle East peace negotiator for Presidents George H.W. Bush and Bill Clinton, was the inaugural speaker. In addition, Ken Feinberg, who was the main administrator for the 9/11 Victim Compensation Fund, joined us last year. Max Factor III, one of the country's leading mediators, was this year's featured practitioner and was just here a couple or 3 weeks ago. With a focus on theory, today's lecture is part of the CISCDR Scholar in Residence series that brings top scholars to our school. We've had previously in this series Carrie Mankel-Meadow and Robert Mnookin. Our guest speaker today shares the esteemed company of his two predecessors. Indeed, I believe he was a colleague of one of them and is now a colleague of the other. The 2007 Scholar in Residence lecturer is Russell Korobkin. He is professor of law at UCLA. In addition to teaching at the law school, he's a faculty associate at the UCLA Center for Health Policy Research and provides private negotiation training and mediation services. He has taught and been a visiting professor at a number of other leading law schools, including this year when he is visiting at Harvard. He teaches negotiation, contracts, and healthcare law, and has written, among other things, a textbook on negotiation theory and strategy. Professor Korobkin received his bachelor's degree and his law degree from Stanford. He clerked on the D.C. Circuit for Judge James L. Buckley and practiced with Covington and Burling before going into academic life. We are honored to have him as the CISCDR Scholar in Residence today. Before I begin, let me just say that at the conclusion of his address, Professor Korobkin will take some questions. Because this event is being webcast, please wait for the microphone so that the people who are joining us via the web will be able to hear the questions. We hope that you'll join us as well after the lecture, for a reception upstairs in Blackacre. Now, on behalf of the law school, it is my pleasure to introduce to you our 2007 CISCDR Distinguished Visitor, Professor Russell Korobkin.
Well, thank you very much. It's an honor and a pleasure to be here. So my thanks to the law school and to especially Professor Sharp for inviting me to spend the day here and giving me the opportunity to address the faculty at lunchtime and also give this public talk this afternoon, as well as get a chance to meet and visit with a number of the faculty members during the course of the day. Integrative bargaining, also known as problem-solving, value-creating, or win-win negotiation, is the centerpiece of normative negotiation scholarship and negotiation teaching. It's held this position since at least the publication of Getting to Yes by Fisher and Urey in 1981, and perhaps even since the publication of A Behavioral Theory of Labor Negotiations by Walton and McCursey in 1965. To begin, let me admit that my talk's title, while intentionally provocative, is somewhat misleading, or at least lacks the subtlety that I hope to convey. I'm not really against integrative bargaining, by which I mean structuring negotiated agreements in such a way so as to increase the joint value of a deal to the participating parties. As a matter of fact, I'm firmly in favor of integrative bargaining. Through integrative bargaining, negotiators can make everyone involved in transactions better off than they otherwise would be, achieving what economists call Pareto improvements. But the value of integrative bargaining, although substantial, has been oversold. This is true, I believe, with regard to negotiation generally, and especially concerning legal negotiations, the term I use for the negotiating context in which lawyers most routinely find themselves. For the past quarter century, the primary normative message of the negotiation theory literature has been that negotiators will achieve better outcomes by focusing their attention on the integrative aspects of bargaining rather than their distributive aspects, by which I mean the division of resources in a way that makes one party worse off to the same extent that the other party is made better off. I call this the integrative bargaining supremacy claim. In my reading of this literature, the dedication to the value of integrative bargaining often takes on a kind of missionary zeal. Practitioners of integrative tactics are seen as modern, sophisticated negotiators. In their search for win-win outcomes, they display subtlety, creativity, intelligence, and sophistication. In contrast, the negotiators who employ distributive tactics are surly Neanderthals who try to use brute force and other boorish, knuckle-dragging behavior to subjugate their opponents. Teaching negotiation is seen as the task of civilizing the great unwashed horde of naive, instinctive negotiators and convincing them to renounce their backward, distributive ways. Now, it is true that while almost everyone has an intuitive sense of how to use some distributive tactics, such as taking a firm position and then refusing to make concessions, individuals who lack formal negotiation training are less likely to intuitively grasp the fundamental concepts of integrative bargaining. And it's also true that the ability to identify integrative opportunities in negotiation is an important and valuable skill for any negotiator to have. But I'm going to argue that negotiations generally, and legal negotiations specifically, have greater distributive potential and less integrative potential than the conventional wisdom suggests. On balance, lawyer negotiators would be better served to think of distributive bargaining as the cake and integrative bargaining as the frosting rather than the reverse. In the first part of my lecture, I'm going to define the concept of integrative bargaining and then describe 4 tactics that negotiators can use to capitalize on integrative opportunities in negotiation. With this background established, I'll then explain how to determine whether a particular negotiation context has integrative or distributive potential, or both. And then I'll provide 2 important reasons that integrative potential is often less than the conventional wisdom assumes, and finally explain why it will often have less potential still, at least relative to distributive bargaining, in typical settlement and transactional negotiations in which lawyers often participate. An agreement is integrative to the extent that it creates additional cooperative surplus compared to some alternative. Because integrative value is relative in this way, identifying it requires the specification of a baseline case for the purposes of comparison. So suppose that Bonnie Buyer is negotiating to purchase a house from Sam Seller. Bonnie's reservation price, defined as the maximum that she would be willing to pay, is $100,000. Sam's reservation price, defined as the minimum amount he would be willing to accept, is $90,000. An agreement, if one is reached, will create $10,000 in social value, or what I call cooperative surplus, relative to no deal, because Bonnie subjectively values the house $10,000 more than does Sam. How that $10,000 is split between them, whether, for example, the price agreed upon is $90,000 or $95,000 or $100,000, is a matter of distributive bargaining. Any gain for Bonnie means a loss for Sam, and vice versa. We can thus say that this deal will produce $10,000 in distributive value, which will be divided based on the distributive bargaining ability of the parties. Now let's assume that Sam is an excellent handyman who enjoys tinkering with things around the house. Bonnie, in contrast, can't fix anything, and she hates having to call service people to the house because she fears she'll be taken advantage of. These facts suggest that more cooperative surplus might be created by the sale of the house if Sam will promise to repair any item that breaks for 1 year after the sale. Let's assume, for example, that this would cause Bonnie's reservation price to increase to $110,000, while Sam's reservation price would increase only to $92,000. Any deal that includes the repair agreement would thus be integrative, because it would create more cooperative surplus than the parties could obtain through the sale of the house standing alone. The extra $8,000 can be understood as the value that can be generated by the negotiator's integrative bargaining ability in this circumstance. Now, this example demonstrates, I hope, what an integrative agreement might look like, but it does not provide an analytically precise description of what the baseline point of comparison should be for a judgment of whether an agreement is integrative. So let me suggest the following definition. For an agreement to be appropriately labeled integrative, it must create more cooperative surplus than the terms of whatever type of agreement would be customary under the circumstances. So if houses were customarily sold with a 1-year repair agreement, agreeing to a sale that included such a repair agreement would still create $18,000 in cooperative surplus, which would then have to be distributed between the parties, but we wouldn't call that an integrative agreement. This definition underscores that integrative bargaining is commonly understood to require creativity on the part of the negotiators, the ability to think outside the box about what is possible rather than simply agreeing to customary terms. With this definition in place, it becomes possible to describe a set of tactics or techniques that negotiators can employ to reach integrative agreements: adding issues, subtracting issues, substituting issues, and log rolling. All four are variations on the theme of searching for ways to reconfigure the term of the deal to increase its joint value to the parties. The simplest way to make an agreement integrative is to add one or more issues that the buyer values more than the seller to the customary set of terms, or what I will call to the negotiation package. The seller of a used car might add a warranty, the seller of a company might add his services during a transitional period of time, or a plaintiff in litigation might add a non-disclosure clause promising to keep the generous settlement price secret to protect the defendant from subsequent nuisance suits. Of course, adding issues to the negotiation package is only integrative if the buyer values those issues more than the seller does. Adding issues that the seller values more than the buyer would reduce the cooperative surplus, not increase it. Assuming that Sam loves the antique chair that sits in the living room, whereas Bonnie considers it the ultimate example of poor taste, adding it to the transaction would reduce the cooperative surplus rather than increase it. Sam's reservation price would increase because he values the chair, while Bonnie's would stay the same because she doesn't, or even increase slightly because she would have to dispose of it. The opposite of adding an issue that the buyer values more than the seller is subtracting something from the negotiation package, taking it off the table that the seller values more than the buyer. Opportunities to profit from this integrative tactic are often more difficult to spot than opportunities to add issues, because the negotiators first have to identify ways to unbundle what often appear to be unitary, indivisible items. If the negotiation package consists of a single house, as in the example I've been using, what is there to subtract or take off the table? Well, as it turns out, ownership of a house can be sliced and diced in many different ways, as can the contents of almost any negotiation package. 2 examples. First, ownership can be divided into physical parts. If Sam loves the original chandelier in the dining room and Bonnie is indifferent, the chandelier can be subtracted from the package. Second, ownership can be divided temporally. If Sam wants to keep the house until his relatives visit in the spring and Bonnie is in no hurry to move, cooperative surplus can be created by subtracting ownership during the next 6 months from the negotiation package and just leaving ownership that takes place after 6 months from now. Sometimes parties can determine in the course of a negotiation that the cooperative surplus they would create by entering an agreement could be greater if they completely changed the subject of the negotiation from what they originally assumed that it would be. Perhaps when Bonnie visits Sam's house, she learns that he has another similar property nearby for sale. The main difference is that the second house is located on a main street and has associated traffic noise, so Sam would be willing to sell it for $85,000 rather than $90,000. The location makes it far more convenient to public transportation, however, which Bonnie values highly because she doesn't own a car. So she would be willing to pay up to $110,000 for it. In this case, substituting the noisy, convenient house for the quiet, inconvenient house, which also could be viewed as subtracting one issue and adding another, should be considered an integrative move. Finally, in many bargaining contexts, the baseline or customary deal includes multiple issues, but the terms that deal with those issues can be changed or adjusted. In this case, it provides some conceptual clarity, I think, to think in terms of log rolling, that is, trading one issue for another, rather than adding or subtracting issues. For example, either Bonnie's or Sam's real estate agent might produce a copy of a standard form real estate contract drafted by the local association of realtors that specifies that the sale will close in 30 days and also provides the buyer with 10 days in which to conduct a home inspection and cancel the transaction if defects are discovered. If Bonnie is leaving on vacation and wants to conduct the inspection after she returns, and Sam wants at least 2 months before he has to move out of the house, the parties can log roll by agreeing to extend the inspection contingency to 20 days and the number of days of closing to 60. Now that I've laid out some basic concepts of integrative bargaining, let me turn to the subject of comparing integrative and distributive potential in negotiation. Now, my governing assumption, I should say, is that most negotiators would wish to choose whether to emphasize integrative or distributive bargaining tactics based on which type offers the greatest potential for creating cooperative surplus for their clients. That is, the goal is maximizing the negotiator's private value, not total social value. Given this assumption, I'm now going to consider the general contextual features that bear on whether distributive and or integrative tactics will have substantial potential value in any particular negotiation. The relative opportunity for distributive gains depends on the degree of competition in the market for goods or services that make up the negotiation package. When negotiating a deal under conditions that approach those of perfect competition, that is, many buyers, many sellers, a commodity product, and low transaction costs, the opportunity for distributive gains will be small. In situations of truly perfect competition, there will be no opportunity for distributive gains at all because both buyers and sellers will be price takers and agreement possible only at a single price point, with both parties being nearly indifferent to pursuing different transactions. $1 more and the buyer won't buy, $1 less and the seller won't sell. In contrast, under conditions of bilateral monopoly, that is, one buyer, one seller, and a unique product with no good substitutes, there typically will be a much larger variance between the reservation prices of buyer and seller. When the seller's reservation price exceeds the buyer's, there will be no opportunity for a mutually beneficial deal, but when the buyer's reservation price exceeds the seller's, the potential benefits to be gained from distributive bargaining often will be quite large. Now, for the sake of comparison, let's imagine 2 people who hope to negotiate the purchase of a car. One, let's call him Carl, is in the market for a commodity product. In this case, a 2008 Toyota Camry. and he plans to go down to his local Toyota dealership, Archie's Autos, this Saturday in hopes of negotiating the purchase of the car. There are lots of buyers in the market for new Camrys. It has been the best-selling car in the United States for 9 out of the past 10 years. And there are many sellers of Camrys, at least in large urban areas. In this circumstance, the bargaining zone will probably be small. No matter how much Carl is dying to get his hands on a new Camry, his reservation price, when he walks into the dealership, will be limited to the price at which he can buy the model at another dealership in the area. If Carl knows from checking newspaper advertisements that another dealer located 10 miles further away is offering the cars for $20,000, then Carl's reservation price is going to be very close to that amount. Let's say, for sake of argument, that Carl's reservation price is $20,100 because once he's in Archie's showroom, it's worth $100 to him not to have to drive to and bargain with the other dealer. Given the assumption that there is competition amongst dealerships, if the competing dealer is offering the cars for $20,000, it's unlikely that Archie can afford to sell the cars for much less than that amount and still turn a profit. In the real world, all sellers are usually not completely identical in every respect, which is to say that conditions are likely to fall short of perfect competition to some extent. So let's assume that Archie has limited space on his lot, so he's willing to sell for a bit less than his competitor down the road in order to free up space to display a new model. And as a result, his reservation price is $19,800, meaning that an agreement between Carl and Archie will generate $300 of cooperative surplus. Now let's consider Carl's friend Ulysses, who prefers more unique automobiles. Ulysses is hoping to purchase a 1930 Studebaker Commander Victoria in near mint condition with the original paint and the original interior. After searching for a number of years, he's located one in the possession of Catherine Collector. Catherine occasionally receives inquiries concerning some of her cars, like her 1957 Mustang, but she rarely comes into contact with anyone who's interested in purchasing a vintage Studebaker. Under these circumstances, there's no liquid market of buyers and sellers to enforce a narrow bargaining range. Since neither Ulysses nor Catherine has a good substitute transaction, this negotiation can be classified as a bilateral monopoly situation. In this case, the parties' reservation prices might be close together by chance, but they also could be widely divergent. For example, it's possible that Ulysses' reservation price might be $80,000, while Catherine's is only $20,000, in which case there would be a $60,000 cooperative surplus to be divided in the case of agreement. In this circumstance, the negotiation's distributive potential would be quite large. Skill at distributive bargaining could be worth tens of thousands of dollars, literally, to Ulysses or Catherine, whereas distributive bargaining skill is unlikely to be worth more than a couple of $100s at most to Archie or Carl. So that's how we determine whether or not distributive potential is likely in a particular negotiation. Now I'm going to turn to integrative potential. While a negotiation's distributive potential depends on the expected variance between the parties' reservation prices, its integrative potential depends on the expected increase in the amount of cooperative surplus that can be created by creatively restructuring or redefining the negotiation package relative to the baseline package. Integrative potential is likely to be substantial when two conditions are present, less so when either is absent. First, there must be a substantial difference in the value of the baseline negotiation package and the reconfigured negotiation package. Second, there must be heterogeneity across parties in the value that they place on the reconfigured negotiation package. If the first condition holds but not the second, integrative bargaining might raise or lower the buyer's reservation price by a substantial amount, but it will simultaneously raise or lower the seller's reservation price, substantially changing the nature of the deal but not increasing the cooperative surplus. If the second condition holds but not the first, integrative tactics are likely to create value, but only very small amounts. To illustrate these points, let's return to the examples of our automobile negotiators. First, let's consider a situation in Condition 1 where Condition 1 holds, but Condition 2 does not hold. So let's assume that vintage car collectors universally place a very high value on the condition of a car's interior. Consistent with this, Ulysses is willing to pay $80,000 for the 1930 Studebaker that has been competently maintained, but he's willing to pay $100,000 if the car is expertly refurbished to look like it did in its original condition. Catherine could have the car refurbished to its original condition, but doing so would make the car far more attractive to her as well. In untouched, used condition, Catherine would be willing to sell the car for $20,000, but if it's refurbished to original condition, Catherine would not be willing to sell it for less than $40,000. In this case, adding the issue of refurbishment to the negotiation package would change the nature of the transaction substantially, but it would not add to the cooperative surplus. Integrative bargaining would have little, if any, potential to create value for the negotiators in this situation. If there's high variance in preferences for refurbishment among vintage car enthusiasts or in costs of refurbishing, the analysis changes substantially. Let's assume, for example, that half of vintage car collectors care tremendously about refurbishment and half don't care at all. The latter group appreciates the patina of time and wear on the car. In this case, adding the issue of refurbishment to the negotiation package might create a very large amount of cooperative surplus. If it turns out that Ulysses is of the type who values refurbishment highly, and Catherine is of the type that does not, adding the issue could increase the potential cooperative surplus of the deal by tens of thousands of dollars. In the way I drew up this example on the board, it would increase the value by $15,000. Under these assumptions, integrative bargaining tactics would have significant potential to create value in the negotiation, although they would not yield value in every single case. Okay, now let's consider a negotiation circumstance in which condition 2 is present, but not condition 1. So in this case, let's assume that Toyota Camry purchasers have heterogeneous preferences for the value of floor mats in their cars. Half find floor mats to be a useful accessory and value them at $50. The other half think that they're practically useless and value them at only $10. Dealers place a very low value on floor mats because Toyota manufactures them cheaply in bulk and provides them to dealers for $25 a set. In this situation, there's a 50% chance that adding a set of floor mats to the new Camry would create cooperative surplus for Carl and Archie, meaning that the negotiation might have integrative value. In this case, the problem is that the integrative value, even in the best of circumstances, will be small in absolute terms. Not irrelevant, but obviously far less important than the price of the car. To summarize then, a negotiation will have relatively more distributive potential if its context approaches bilateral monopoly than if its context approaches perfect competition, and it will have relatively more integrative potential if the possible changes to the baseline transaction significantly affect the overall value of the transaction, and the variance in negotiators' valuation of those changes is high. This analysis provides a construct for comparing the integrative and distributive potential of a given negotiation, but it certainly doesn't demonstrate that the integrative bargaining supremacy claim is misguided, even on average. Under this type of analysis, it's possible for any negotiation to have relatively greater integrative bargaining potential or relatively greater distributive bargaining potential. Now I'm going to turn to my argument that first, integrative potential is often more limited than it might seem to be, and second, that we should expect the majority of legal negotiations to have relatively high distributive potential and relatively low integrative potential. Even in conditions that appear to have integrative potential, there are two reasons that I'm going to emphasize that the value of integrative tactics might be less than first meets the eye. When issues are added to the baseline negotiation package, those issues are often separable from the content of the customary package. For example, rather than adding the floor mats to the sale of the Toyota Camry, one could imagine Carl and Archie entering into a contract for the sale of the Camry, and then a month later, Carl returning to the dealership and negotiating for the floor mats separately. Let's assume again that Carl's reservation price for the car is $20,100 and Archie's is $19,800, and that Carl's reservation price for the mats is $50 and Archie's is $25. Assuming separate negotiations, we would characterize each negotiation as a purely distributive negotiation. The negotiations would be entirely zero-sum. Now, for this reason, Professor Gerald Wetlaufer has argued in the past that adding the issue of floor mats to the negotiation concerning the Camry is not an example of integrative bargaining at all. I disagree with his analysis on this point. If Camrys are customarily sold without floor mats, adding the issue of the floor mats does increase the amount of cooperative surplus available to the parties. Carl's reservation price for the package of Camry plus floor mats would be $20,150, and Archie's reservation price for the package would be $19,825, increasing the overall cooperative surplus from $300 to $325. It is true that combining the issues does not produce any more cooperative surplus than the parties could have created by negotiating twice, once for the car and then once for the floor mats. But the double negotiation scenario is probably not the appropriate baseline case for comparison. If the parties don't add the mats to the Camry transaction today, it's unlikely that Carl will return next month and negotiate for them separately. If my intuition about this point is correct, the proper baseline transaction for evaluating whether there's integrative potential or not is the cash for car transaction, not a cash for car transaction plus a separate cash for floor mats transaction. The problem for integrative bargaining supremacists, as I see it, is not Professor Wetlaufer's criticism. It's that in many examples often used to demonstrate integrative potential, it would be more efficient for one or both negotiators to enter into the second part of the transaction with a third party than with their immediate negotiation counterpart. When this is the case, the use of integrative tactics such as adding issues will increase the cooperative surplus available to the parties in the particular negotiation, but produce less overall value than they could have been achieved through alternative course of action. It might be the case that Toyota can produce floor mats that fit Camrys particularly cheaply, or that Carl places a high subjective value on having floor mats with the Toyota insignia. In this case, adding the floor mats to the negotiation would create overall value. But if a third-party vendor could produce an equivalent product more cheaply, and if Carl doesn't care about the Toyota logo, more cooperative surplus would be created if Carl were to purchase his floor mats elsewhere. Okay, to generalize from this example, bundling issues together can often obscure the fact that integrative tactics can make parties better off than they would have been had they just made the baseline transaction alone, but leave them worse off than they would have been had they dealt with a third party regarding those additional issues. This risk demonstrates an important limitation on the overall potential of integrative tactics to create value for negotiators. The second reason that I want to emphasize that negotiators should be skeptical about the relative potential of integrative tactics as compared to the potential of distributive tactics is an important asymmetry between the two types of tactics. Skillful use of integrative tactics increases the opportunity a negotiator has to benefit from skillful use of distributive tactics, but the reverse is not true. Let's create a set of facts that make integrative tactics appear to have far more profit potential than distributive tactics. Assume that Ulysses has a reservation price of $40,000 for the 1930 Studebaker, and Catherine has a reservation price of $39,000, just a little bit lower. Ulysses would value the car refurbished at $60,000, and Catherine, who considers refurbishing vintage cars a relaxing hobby, is willing to do the work for $2,000. Assume that no one can refurbish a Studebaker as well as Catherine, and also assume that because she considers doing so fun rather than work, no one can do it for cheaper. So adding the issue of refurbishment to the baseline negotiation package will not mask a more efficient possible transaction with a third party for either negotiator. In this example, the distributive potential of the negotiation seems small. It's just that $1,000 difference between $39,000 and $40,000. But its integrative potential seems very large. Integrative tactics in this case can add $18,000 of cooperative surplus to the deal. This analysis is correct as far as it goes, but it doesn't go far enough. By employing the integrative tactic of adding an issue, the parties have created $18,000 of cooperative surplus, sure enough, but that surplus must be divided. The parties can capture that integrative potential only if they now are able to agree on a sales price somewhere between $41,000 and $60,000. And that price is going to be determined based on the negotiator's skills in using distributive tactics. The more integrative potential of a negotiation, the more the potential value of distributive bargaining as well. This principle holds true even if the negotiation's not over money or over price. Consider a divorcing couple who owns a townhouse in the city and a cottage in the country, each with approximately the same market value. Their lawyers advise them that a standard divorce agreement calls for the sale of non-liquid assets and an equal division of the proceeds. And in fact, if they do not agree to a division of their property, a court will order exactly this. Husband Harold hates the congestion of the city and loves the clean air of the country. Wife Wendy loves the energy of urban life and despises the isolation of rural life. Clearly, cooperative surplus can be created if Wendy keeps the townhouse and Harold the cottage, because each would enjoy far more than half of the subjective value that's produced by the two assets. Make no mistake, however, the integrative potential of this negotiation makes distributive skills more rather than less important, as long as side payments are possible, which they virtually always are. Precisely because she values the townhouse much higher than the cottage, Wendy would prefer to keep the townhouse and pay Harold a significant cash amount in compensation rather than go to court. And because Harold values the cottage so highly, he would prefer to keep it and pay Wendy significant cash compensation rather than go to court. Which spouse pays the other in cash or marital assets as part of the deal? The answer will depend on the exercise of distributive tactics. Now, many of you might have the intuition that the most likely outcome in this negotiation is that each spouse simply keeps his or her preferred house, and neither is going to end up making a side payment. I agree with this empirical conjecture, but the reason that such an outcome is likely is because one or both parties might argue that payments are inappropriate when each spouse obtains an equal amount of objective value by simply keeping his or her preferred residence, because an agreement to make no side payments is a salient focal point amongst an infinite number of possible arrangements, or because it's customary not to exchange cash in this type of exchange. Employing any of these arguments to reach an agreement, however, constitutes distributive bargaining. These are all distributive tactics. From the standpoint of negotiation theory, there's no such category as legal negotiation. There are, however, some negotiation contexts in which the participation of lawyers is ubiquitous. Certain characteristics of these contexts suggest that lawyer negotiators in particular will tend to have more to gain for their clients through their skills in distributive tactics than through their skills in integrative tactics. Perhaps the prototypical bargaining context involving lawyers is the out-of-court settlement negotiation, in which the negotiators seek to exchange the waiver of the plaintiff's legal claims for some consideration, usually money offered by the defendant. Since the large majority of all lawsuits are resolved through negotiation rather than adjudication, settlement negotiations might actually be called the primary business of litigators. With a few very narrow exceptions, settlement negotiations reflect nearly perfect bilateral monopoly conditions, which suggests that distributive potential is likely to be substantial. If Walker files a lawsuit against Driver for negligent operation of her automobile, neither has the option of walking away and settling the claim with a third party instead of with the other litigant, in the way that Carl can purchase his Camry from dozens of Toyota dealers, or even a similar car from many other automakers, if he thinks Archie is trying to drive too hard of a bargain. The distributive potential of litigation settlement negotiations is reinforced by the fact that transaction costs of pursuing adjudication are high, and the outcome of adjudication is almost always uncertain. Assuming that litigants are risk-averse, both of these factors suggest that not only are plaintiff and defendant likely to have divergent reservation prices in settlement negotiations, in most cases we should expect that the defendant's reservation price will be higher than the plaintiff's. In such circumstances, the cooperative surplus that can be produced by a baseline agreement, the exchange of cash for the waiver of the plaintiff's claims, will often be very large. While the distributive potential of settlement negotiations is on average large, their integrative potential, I contend, will usually be small. Where the litigants have an ongoing relationship, it's conceivable that they could add issues concerning the relationship to the negotiation package and create integrative value. For example, a defendant could promise to place future orders with the plaintiff in return for the plaintiff dropping his breach of contract suit. But this tactic can increase joint value relative to the baseline transaction only if the dispute has not sufficiently poisoned the relationship to the point that continued dealings aren't feasible, and the parties would not have independently entered into the same agreements concerning the future. And this possibility of creating integrative value, of course, does not exist at all in settlement negotiations when the lawsuit is between strangers or near strangers. A common example of one integrative tactic that can be used in a settlement negotiation, even between strangers, is the addition to the negotiation package of an apology by the defendant. Adding an apology often will be more valuable to the recipient plaintiff than costly to the issuing defendant, so it has the possibility of creating cooperative surplus. But except in cases where reputational damage has caused long-term harm to a plaintiff's financial interests, apologies usually have a small amount of value in comparison to the issue of damages. Consider a wrongful death plaintiff willing to accept $1 million to settle his claim out of court, and a defendant with a reservation price of $1.5 million. If the defendant offers to add a formal apology to a settlement, the plaintiff's reservation price, in reality, is likely to decline only slightly. A gratuitous apology, that is, one provided without the explicit condition that it be considered part of the compensation package, offered by the defendant at the outset of the negotiations, is likely to be a very good distributive tactic because it's likely to engender goodwill and cause the plaintiff to be less recalcitrant when the parties bargain over that $500,000 of cooperative surplus. But the apology probably has only modest potential to actually expand the bargaining zone and thus increase the total amount of cooperative surplus available. Now, perhaps I've convinced you that settlement negotiations will tend to have more distributive than integrative potential, at least on average. But what about transactional negotiations conducted by business lawyers that grease the wheels of commerce? Most business negotiations are not defined by bilateral monopoly conditions, and many offer the possibility of significantly changing the overall nature of the transaction by adding or subtracting issues or by log rolling. For these reasons, it's clear that the relative potential of integrative bargaining compared to distributive bargaining is far greater on average in transactional negotiations than in distributive ones, but the relative potential of integrative bargaining can still easily be overstated even in this context. I'm going to give two reasons why. The first reason is that in many transactional negotiations, the clients agree on the foundational structure of the negotiation package, including perhaps the price, before the lawyers become involved. At this point, the business executives call on their legal department or their outside attorneys to paper the deal with a formal contract, and it's only at this point that the lawyers step into the center of the negotiation. Under these conditions, the negotiation context looks far more like a bilateral monopoly, and the value of distributive skill increases substantially. Although both parties technically retain the option to walk away from the negotiation and enter into an agreement with a different party, the transactional and reputational costs of doing so at this point can be quite substantial. In addition, the lawyer as an agent faces high personal costs of recommending this course of action to her client because she risks being labeled as a deal killer. In this situation, there will actually be a large bargaining zone in many cases, which is to say that both the buyers and the seller's lawyers will prefer to sacrifice a substantial amount of cooperative surplus that a completed transaction would create rather than break off negotiations and recommend cancellation of the deal to their clients. This feature, common in business transactions at the time that the lawyers enter into the picture, suggests that distributive tactics will actually be quite valuable, more valuable than initially might be assumed. While the distributive potential of transactional negotiations is often greater than it initially appears to be, the integrative potential of transactional negotiations is often relatively less than it first appears because the widespread adoption of trade custom can incorporate into the baseline negotiation package many efficiencies that integrative bargaining might otherwise capture. This is true for large-scale business transactions generally and for industry-specific negotiations in which transactional lawyers develop specializations. Take, for example, a merger negotiation in which a large conglomerate, Alpha Company, seeks to purchase a small high-technology company called Beta. Beta's value to Alpha is primarily in the former's portfolio of technology patents. Because Beta has more information than Alpha about whether competitors might seek to challenge the validity of those patents on the grounds that they are not sufficiently novel or non-obvious, Alpha's reservation price is likely to increase more than Beta's reservation price will increase if Beta provides a contractual representation that it has no knowledge of any current challenges to its patents and also agrees to indemnify Alpha for harm suffered if such a challenge is subsequently mounted by a third party. On its face, this example looks like an excellent one for integrative potential. And indeed, it would be if we were to assume that the baseline transaction from which we judge integrative potential between Alpha and Beta would include no representation and no indemnification provision. This probably was a fair description of the baseline situation the first time one company purchased another, principally for the latter's patent portfolio, and consulted a lawyer for assistance in structuring the terms of the deal. In most transactions, however, lawyers do not begin negotiating the terms of a complicated deal from scratch. Instead, they draw on a large base of institutional memory and industry custom. Where this is the case, the value of providing these type of terms, like the representation and the indemnification provision, is captured by customary practice. That is, we assume that even uncreative negotiators are going to include those terms in the agreement because they use a standard contract or consult other contracts that have been written for this type of negotiation in the past, and custom serves to incorporate these provisions into the baseline. And the integrative skill of the negotiators in this particular transaction will be correspondingly limited. Now, my claim here is not that integrative bargaining has potential to create value only in transactional negotiations that are completely novel. Even when custom establishes a baseline set of terms that captures the integrative potential common to a certain type of negotiation, the lawyers often find integrative opportunities by building on the unique or idiosyncratic preferences, needs, and cost structures of their particular clients. My point, though, is that the amount of value that can be gained only if the lawyers negotiating the deal are personally skilled at using integrative bargaining tactics is often much less than what is assumed in the typical negotiation classroom, where the acquired wisdom of industry-specific custom that informs baseline transactions in the real world is rarely assumed. Now, let me close by reiterating that notwithstanding the title of this lecture, my criticism is of the integrative bargaining supremacy claim, not integrative bargaining itself. My argument is not that integrative bargaining lacks value, but more modestly that the majority of legal negotiations will have more distributive than integrative potential, an argument that I've tried to support, admittedly circumstantially, by showing that these types of negotiations will usually have substantial distributive potential, and at the same time their integrative potential will tend to be more limited than is commonly assumed. What has been most obviously lacking in my lecture, perhaps, is a description of the tactics that negotiators might use to take advantage of all this distributive potential that I claim is out there for lawyer negotiators. So let me close by just saying that distributive bargaining is itself a complex activity that deserves a detailed and nuanced analysis. Proponents of integrative bargaining supremacy sometimes caricature distributive tactics as being limited to making unreasonable demands and then refusing to make concessions. Although aggressiveness and even stubbornness do have their place as tactics, distributive bargaining is certainly not limited to these stereotypic behaviors. A savvy bargainer who focuses attention on distribution, devotes resources to improving her options away from the bargaining table, understands the needs of her counterpart, invokes external norms as the basis for reaching decisions, uses social norms of fair bargaining in order to reach an agreement, and builds and develops a reputation as a fair and honorable business partner. Unfortunately, a discussion of how a negotiator can best combine these approaches in order to achieve success at capturing cooperative surplus from her counterpart, that is, at distributive bargaining, will have to, because of time constraints, be a topic for another lecture on another day. Thank you for your time and attention. We have a few minutes for questions, so would you like me to just call on people, or do you want to? Oh. Oh. Okay.
I'm going to be, can you hear me? Or, okay. I'm going to be passing around the microphone, and if you could be sure to hold it close enough to your mouth that it picks up the sound of your voice. So, any questions?
I've left you all speechless. Down here.
I want to thank you, Russell, for a well thought out presentation on this question of integrative bargaining in really great detail. But I guess I have a more general question. I'm wondering whether your posture or position on integrative bargaining, as you've laid it out here, is a critique of Fisher and Urey, and if so, how so?
Is it a critique? So for those of you that are not familiar, Fisher and Urey's book, Getting to Yes, is almost certainly the most popular and best-selling book ever written on the subject of negotiation. And they are really huge proponents of what I call integrative bargaining. So it's a critique of them, it's a critique of not of what they say, but what they don't say, right? So, as I said in the talk, that my criticism is not of integrative bargaining, but with the integrative bargaining supremacy claim. I'd say Getting to Yes is a book is perhaps the prime example of integrative bargaining supremacy. So in their book, they talk about all of the tremendous virtues of integrative bargaining, but they completely downplay the virtues of distributive bargaining, or the opportunity for to capture value in negotiation from distributive bargaining. So it is to that extent a critique. There's nothing in Getting to Yes. I think Getting to Yes is a tremendously useful book, but I don't think it gives a complete view of the world. It gives a view of a narrow portion of the world, and it's right as far as it goes. But as I said in my lecture, oftentimes the arguments about integrative bargaining are right as far as they go, but they don't go far enough. So I would say the critique of Getting to Yes is not recognizing or pointing out. I'm sure Fisher and Urey, well, I'm not sure. I assume Fisher and Urey would understand these limitations that I point out today. They don't point out this limitation in their book, and they don't point out the comparative potential value of distributive bargaining as well. So it makes it tends to make, I think, students of negotiation think that they should completely ignore attempts at distributive bargaining and focus only on identifying ways in order to increase the cooperative surplus of the transaction, right? So to me that's not the whole picture. And I think that, just saying that probably doesn't set me apart from a lot of people. Most negotiation scholars would agree that that's not the whole picture, that distributive bargaining has some role. But I think the conventional wisdom is that, relatively speaking, integrative bargaining is where the civilized, as I said, civilized and cerebral negotiator places his or her emphasis, and not distributive bargaining. And I'm arguing for an evening of the scales, and actually I would say I'm arguing for placing distributive bargaining on the importance scale somewhat above integrative bargaining.
I guess the integrating people would say you should focus on increasing the size of the pie instead of how to split the pie, because everybody's better off if we increase the size of the pie. Of course, that assumes that they don't take any ingredients from third parties. But part of what your thesis seems to me is that most of the time the increase is less than the size of the pie to begin with. And so if you are trying to be a selfish, self-centered negotiator, you should be concerned about maximizing the size of the pie that your client gets as opposed to the size of the pie that the other side. But I thought that Fisher's and Urey's position in part was focusing on the distributive interferes with and makes it more difficult to increase the size of the pie. Not merely that one was more important than the other.
Okay, so a couple of interesting and important points there. The first is the basis of the integrative bargaining supremacy claim the normative position that one should try to maximize total social value rather than one's individual value from the negotiation. And I would say that in that community of the people I call integrative bargaining supremacists, I would say that there are some people that would take that position. But the way integrative bargaining, I think, is better sold to lawyers and business people is not as a utopian model, but as a method of actually creating more value for your particular client. So I think and I think that that's just being realistic, right? If one is negotiating with a close friend or a family member or a spouse, one's goal might be to make the pie as big as possible, and there might be little concern with exactly how much of the pie I get. But in the kind of business, professional circumstances that lawyers and business people find themselves in on a daily basis in their professional lives, I think that that's just not the way the world operates, right? One has a fiduciary obligation to one's client, and you want to do the best for your client. Now, that's not to say that you don't care at all about how the other party does. For reputational or relationship reasons, you would almost certainly be smart to make sure that the other party gets something positive out of the deal, right? Doesn't just get the bare minimum, because satisfaction is going to serve a lot of benefits for your client down the road. But the primary goal is one's own cooperative surplus or one's client's cooperative surplus. So that's the first point. And I think most people that urge integrative bargaining would say, yes, we don't dispute that, but we think integrative bargaining will actually do a better job of that than distributive bargaining. That's the point, of course, I disagree with. Now, as to your second point, that so one more subtle argument for integrative bargaining might be that if the negotiator focuses on distributive bargaining, they will completely forget to look for integrative bargaining opportunities. So focusing on integrative bargaining is a way, and ignoring distributive bargaining is a way to make sure that you don't ignore these possibilities to create value with integrative bargaining. And, I mean, I suppose that that's true, but there's no inherent reason why a negotiator shouldn't be able to think about ways to add, subtract, substitute issues or log roll in order to create value. At the same time, they're thinking about how they can capture as much of the cooperative surplus as possible. So I don't see why, as a theoretical matter, one should have to choose one or the other. And if one the problem actually is more in the other direction, I think, that integrative bargaining always requires distributive bargaining. If you're really good at integrative bargaining, you're making the pie bigger, you have to distribute the pie. You have to cut it up. And this is a point that I think that is often missed by the integrative bargaining supremacists because they don't take seriously the possibility of side payments, right? But of course, side payments in cash or in kind are always possibilities in almost any kind of situation. And so you really have to, distribution is part of any successful integrative tactic, but the reverse is not true. If there's only one issue, and the parties have competing preferences on that one issue, there might be enormous distributive potential and no integrative potential at all. So I think if you have to focus on one or the other, my argument is on the distributive side.
As long as I've got the microphone, much of the literature about mediation claims that mediation can increase the pie, and that the mediator can imagine ways of increasing the value for both parties. Wouldn't, therefore, your thesis have important implications on what the role of a mediator ought to be?
Yeah, I think my perspective might help to bring the theory of mediation, the academic theory of mediation, closer and more consistent to what most practitioners of mediation will tell you, which is that there are some opportunities for integrative bargaining in the mediation context, but mostly settlements occur when the parties agree on how to distribute the value. So as an example, from one case that I mediated once, where here's an example of integrative potential in mediation. It was employer suing a former employee for wrongful termination. Setting aside the facts of the case, there was a lot of dispute over whether the termination was indeed wrongful or not, and the parties were negotiating over how much money the defendant might pay to settle the case out of court. And I suggested to the defendant's lawyers that maybe they would consider the possibility of rehiring the plaintiff and with some kind of safeguards in place to make sure that the behavior that they had accused the plaintiff of would not happen again if it ever happened in the first place, and that the plaintiff would agree to some type of terms for monitoring. So there's an opportunity for integrative bargaining, but even if the parties then agree to that, then there's still the question of okay, and how much money is the plaintiff going to get from the defendant in addition to that? Or, of course, the side payment could go the other way, right? If the job is extremely valuable, getting it back has value, you could even imagine that the defendant would say, okay, we'll give him his job back, but he has to take a lower salary, right? So that's a form of side payment going the other way. So even in that case, which is, to me, the best example that I've ever seen personally of integrative potential in a mediation setting where there's actual litigation going on, you still have distributive potential. Whereas in many mediation contexts, between when the litigants are strangers, there's virtually no integrative potential that anyone is interested in, and and a lot of the mediator's job is to guide the parties towards a joint evaluation of the legal merits of the case and the likely results of adjudication, and then settlement is based on that agreement. On agreement on those facts, or those facts plus the consideration of transaction costs. And that's all about distributive bargaining. That's just entirely distributive bargaining. Are we out of time?
I think we're out of time. But so I want to thank you very much for a terrific lecture and wonderful discussion. Before we let's. Now, before we break, I am told that there is a little something under here that I'm to give you as a token of our esteem for you as our lecturer, and I guess we have a shirt.
Very nice.
Something else here?
Okay, and something else in this box as well.
And the test is going to be, can you open the box?
Can I open the box in front of the video camera? Let's see.
There must be a way. Okay.
Oh, and a Case Western automobile mug as well. That won't spill coffee on myself in the car.
Well, and in our library.
And in the library.
Okay, well, thank you very much.
Thank you so much.
And